Today's talk is on the Youth Court, Practicalities and Opportunities. Now, this will be broken down into three sections. The first is first appearances and sentence. Then we'll move on to modern slavery defences and finally certificates of counsel. Now let's dive right in. Firstly, in the first appearances, these are very similar to those of adults. However, in court, there'll also be the youth offending team, who are known as YOT, and that the child or young person has a right to have their parent, guardian, or if they're in the care of social services, to have a social worker with them at all stages of the proceedings, unless the court is satisfied that it is unreasonable in all the circumstances for this to happen. So moving on to sentences, the main focus of sentence for youths are the welfare of the child and prevention of crime. Now, the cut-off age in relation to children and young people, as I'm sure you're all aware, is 18, and this is down to maturity and neurological development. I'm sure you're all aware there's also ample evidence that individuals' brains don't stop developing till around 21 to 25. Now, in relation to guidance, there are the Sentencing Council's guidance on young people and children. And effectively what that is saying is that when you're dealing with a young person or child, that when they are aged between 15 to 17, the sentence should be somewhere in the range of 2/3 to half of the sentence for an adult. And when they are below the age of 15, that this will be greater. And although the court does have discretion to give a sentence in excess of this, the case of Moorhouse states that if they do this, an explanation should be included in the sentencing remarks. Now, what is a situation when a child or young person reaches the age of 18 before the proceedings are finished? Now, the position is that they remain in the youth court and they are treated as if they had not attained the age of 18. Now I'm going to take you through the primary means of disposal, i.e. different type of sentences, and there is a table in your handout which starts at page 2. So firstly, we have reparation orders. These are that the offender makes reparation other than compensation to a particular person or persons or the community at large. Now, if this is to a particular person or persons, you must have their consent and their name should be included in the order. And the order should also include the work which the individual will be undertaking. Now, the maximum period of work is 24 hours, and this should be completed in 3 months. Now, the age of conviction for these, so who can these be applied to, are individuals between 10 to 17. Now, a reparation order cannot be imposed if a youth rehabilitation order is in place unless it is revoked, and you need a pre-sentence report. And in that report, it should include the attitudes of the victims to the proposed work. Nextly, we have referral orders. These are essentially that the young person attends a meeting with the youth offender panel. These can be imposed for individuals 10 to 17. They are not available to the Crown Court, sitting as a court of first instance, and they can be imposed when there is a guilty plea to the offence or connected offence. Next, we have the youth rehabilitation order. There are 3 types of these orders. Firstly, the basic, which is one or more requirements. Secondly, the fostering order, which includes a fostering requirement as well as supervision. And finally, a order which is intensive and with supervision. and surveillance. This can be imposed for a minimum of 6 months and includes an extended activity requirement, supervision, and a curfew. And when the court imposes this, it must be satisfied that the offence is so serious that it warrants the making of the order. For the latter two types of these orders, the offence needs to be so serious that a custodial sentence is appropriate. If it is imposed on those under 15, they must be a persistent offender. The requirement can stay in place for 3 years, and there needs to be a pre-sentence report. In the table that you've been provided, there are a list of different requirements that can be imposed, which I don't propose to go over. Next, we have the detention and training order. This is the only custodial sentence for those who are not convicted of an offence for which there is a maximum of 14 years, or certain sexual offences. In terms of how these are served, half is the detention and training, the other half is the supervision. Now, they can't be imposed for those between 10 to 11. For those 12 to 14, it is available if the individual is a persistent offender, and it is available for those 15 to 17 without the requirement that they are a persistent offender. These orders can be imposed for set lengths, 4, 6, 8, 10, 12, 18, or 24 months. Now, it's important to note in court that time spent on remand or qualifying curfew is not automatically deducted. So you'd be asking the court to account for this when they are passing the sentence. The next type of order we have is the detention under section 250, which is available in cases which are punishable with prison for 14 years or more in the case of an adult, certain sex offences and firearms offences with a minimum sentence applies. They're available to those 10 to 17, and the section 249 criteria must be met. Next, we have the extended determinate sentence. These are custodial sentences with an extended licence period. The extended licence period is a minimum of 1 year and goes up to 5 years in the case of specific violent offences, and 8 years in the case of specified sexual offences and specified terrorism offences. The dangerous criteria must be satisfied, and the offence must be one in which detention under section 250 is available, and the custodial term must be at least 4 years. Then we move on to the most serious type of sentences. Firstly, required sentence of detention available to those 10 to 17, and they must be convicted of a Schedule 19 offence, and the dangerous criteria must be met. Then we have detention at Her Majesty's pleasure, which is for the offence of murder. It is called detention at Her Majesty's pleasure when it is an individual who is between the age of 10 to 17 at the time of the murder. Essentially, when you're sentencing, you're looking at the age of the individual when the crime was committed, not at date of conviction or sentence. And the starting point is 12 years. Then we have financial orders, which are available to those 10 to 17. Fines for those age 14 or under is a maximum of £250. For those 14 or over, it's a maximum of £1,000, and compensation can be up to £5,000 for each offence. Now, there are certain circumstances in which the court can order the parent or guardian to pay the fine. However, usually there needs to be a nexus between the offending of the individual and the behaviour of the parent or guardian. Now, that concludes the first section of our talk, and we're going to now move on to modern slavery defences. Now, the modern slavery defence is included in section 45(4) of the Modern Slavery Act 2015. And this is where a person is not guilty of an offence if the person is under 18 when the person does the act which constitutes the offence. The person does the act as a direct consequence of the person being or having been a victim of modern slavery or a victim of relevant exploitation, and a reasonable person within the same situation and having the person's relevant characteristics would do that act. Now, Schedule 4 of the 2015 Act lists 140 offences at which Section 45 does not apply. If it is one of these offences, it's always worth approaching the Crown and asking if it is in the public interest to pursue that case. Now, I thought it would be beneficial to go over what the prosecution's obligations are and the process they need to take when they are faced with one of these offences. Before I go over the general list, there are two very specific points in relation to youths. Firstly, there is a duty to inquire as to age, which is very much self-explanatory, and that is to make due inquiry and take such evidence as may be forthcoming to determine the age. The issue of age should be finalised as soon as possible, and there are the CPS guidance concerning age. Next, we have the presumption that the child is a victim, and essentially is if there are reasonable grounds to believe that the victim is a child, there is a presumption that they should be treated as such. Now, in terms of the assessment which the CPS need to undertake, the first question they have to answer is there a reason to believe that the person is the victim of trafficking or slavery? Now, there are duties to make inquiries through the national referral mechanism, and when you're dealing with the youth, this should be done through social services. Now, if the answer to that question is yes, we then move on to the next part of the assessment. If the answer is no, then there's no requirement to consider the assessment any further. So moving on to the second question, that is there clear evidence of a credible common law defence of duress? Now, the following definition is widely accepted, and this is a threat of physical harm to the person, including possibility of imprisonment, made which was of such gravity that it might well have caused a sober person of reasonable firmness, sharing the defendant's characteristics, and placed in the same situation to act the way the defendant did. If the answer to that is yes, then effectively the case should be stopped. If the answer is no, and then we move on to the third question, and that is there clear evidence of a statute offence under section 45 of the Modern Slavery Act, which we have gone through. However, the burden of proving this is on the defendant, and they essentially just need to pass the judge so that the defence can be put to the jury. Once the trial starts, the burden then flips, and it is on the Crown to disprove the defence beyond all reasonable doubt. If the answer to this is yes, then the case should be stopped there. If no, we move on to the last question, and that is it in the public interest to prosecute? As I'm sure you're all aware, this is a discretionary test and rather broad, but effectively they need to consider all the circumstances in the case, such as the seriousness of the offence or direct or indirect compulsion from their trafficking. Now that concludes my section of the talk, and I'm going to pass over to John to take you through the remainder of modern slavery defences and certificates of counsel.
So the next parts in relation to modern slavery they'll be looking at is a little bit in terms of how the process works itself. So how actually getting the referral through to the national referral mechanism works. And the first part of that is that only certain bodies are able to actually make the referral to the NRM. And perhaps most importantly for our aspect, that doesn't include anyone sort of traditionally in the defence roles. It doesn't include the defence solicitors or any defence advocate, but it does include things like the police, local authorities and certain charities, including Barnardo's and the Salvation Army. So if you think in your case that there are issues in relation to modern slavery, depending on the situation of the young person, it might be that they're already involved with the local authorities, you can approach through that way, or it could be that you simply have to rely on informing the court and the prosecution and trusting in the police to make the referral to the NRM. The next step, once the referral's been made, is that the NRM will go away and will come back with initial grounds in relation to whether or not the modern slavery arises as a possibility. And those initial grounds set out the NRM's primary initial view in relation to them, as the name suggests. And then that's only obviously a holding position while they go on to consider their conclusive grounds in relation to whether or not modern slavery exists in the case that's being put before them. Now, actually getting to a situation where the NRM reaches a decision as to whether or not there are conclusive grounds for believing that modern slavery exists can be a very slow process, often taking a number of months. Effectively, the mechanism is somewhat overwhelmed by the number of requests that have been made to it, and it can be very slow. And it is something that often the courts are quite frustrated by, and quite often be quite critical of the defence that these things aren't being done sooner and it isn't a decision isn't available. But ultimately, it's something beyond the defence's control, and because in these cases, determining whether or not effectively this young person should be treated as a victim is such an important decision. To a certain extent, the court has to accept that there's very little it can do to force these decisions to be made to happen faster, and it's effectively got to wait for the NRM. But often, obviously, that's not a very popular thing to be saying in court. As well, it's also worth noting in speaking to your client about this that often the NRM you need to speak to them, your client themselves, about the incident in the background. So it's worth warning your client that that's likely a conversation they're going to have, and that in reality it's in their best interests to cooperate with the NRM and tell them sort of frankly about what's happened, because obviously as part of the offence you're accepting the conduct that the Crown say is taking place, but are putting this forward as a complete defence to it. So once that process has been gone through and there are conclusive grounds, obviously, if they're negative, then it's obviously says at the end of the NRM's engagement and the end of any use that could be to the defence. But if they're positive, then obviously you can use that as a renewed effort for the CPS to reconsider and see whether they still wish to pursue the case. If the matter does proceed to trial, either in the youth court or obviously if it goes to the Crown Court, this is equally applicable, then the evidence can be put forward of the fact that the NRM have reached this decision. So the conclusive grounds can be adduced as evidence in the case. There's the DPP&M is the case that discusses that. But it is also worth bearing in mind and also worth pointing to the client that it's not necessarily decisive. So the finding of modern slavery isn't exactly the same as saying that the statutory requirements of the defence are met. So you've still got to set out and meet the statutory criteria to engage the defence. But even if the client is ultimately convicted, no matter sort of how far through the NRM process you get, it's likely that some part of that engagement can throw up evidence that can be very useful and powerful in mitigation, and can also just use to change the kind of the way your client's viewed by the court, even if they are convicted. If it does then come to sentencing, the information within that can often be quite helpful. So it's definitely a process worth going through if your client raises it. And in relation to that, it is also worth bearing in mind that often with people in this situation, if they have been exploited, it's very likely that it might not be something that they're very happy or willing to talk about. So those of you who work in youth court, I know you're very aware that sort of young clients can often be very reluctant to trust adults and to speak to them and explain to them what's happened. So it could well be that this isn't something that you're told about by your client until sort of significant way into the case, some way down the line. And even then, it is worth trying to go through this process and explain to the court that, look, for these reasons, you've not been gotten these instructions yet, and that it is well worth exploring whether or not the NRM think that there are the grounds that exist. And it obviously then opens up the existence of this statutory defence to you as well, if those are your instructions. So that's a general overview of how sort of the process of NRM referral works within the context of an individual hearing. And now we'll move on to the third and final part of the talk in relation to certificates for counsel. And this is applications that can then allow, as the name suggests, to an advocate to be instructed alongside a solicitor in relation to the case. So it obviously expands the legal aid that's provided. And you can see in the handout there that it's under the legal aid 2013 regulations, the test that needs to be met in order for the certificate to be granted. Just a point of interpretation, obviously, in this context, advocate obviously is a junior counsel, and applications to instruct Queen's Counsel are separate entirely, and that it's anyone who holds higher rights who can then obviously be instructed in relation to the certificate. So the way that an application works is that they are sort of being addressed here in a youth court seminar. They can be applied for in any case in the magistrate's court. But the reality is that given youth courts hear much more serious cases than magistrates' courts will, that in reality in youth court cases it's far more likely that the criteria for having a certificate will be met, and that the way the application is drafted, it's normally drafted by the advocate that's intended to be assigned, it's in writing, and it's submitted then to the court setting out the reasons why they say the test is met in relation to the legal aid regulations. We're looking at those regulations, obviously only can be applied for in indictable offences, so indictable either way, and matters both count. And the test, important to bear in mind, is whether it will be desirable, not whether it's necessary, not suggesting that it's impossible to be conducted just by a single individual, but whether or not it's desirable for a certificate to be granted. And then it's an either or, so that either the proceedings to be unusually grave or difficult, not necessarily both, although often it can be the case that you can argue both limbs and hope that one of them is successful. Also there in the handout, you'll see some comments from the Inns of Court College of Advocacy. They've given some quite helpful guidance in relation to essentially applying for certificates for counsel in youth court cases, that they're keen for this to be something that's used more and to sort of build a more specialised approach towards youth court advocacy and get more people involved in sort of more focused work in relation to youth courts, because making the point that if a lot of the more serious cases in the youth court, had they been adults, they would have been committed to the Crown Court, and then they would have been entitled in any event to counsel and solicitor in relation to their case, so that clients shouldn't be prejudiced by their age in terms of the funding and the access to legal support that they can get. So that's obviously one of the kind of key factors that you can make in any application, that the client shouldn't be disadvantaged because they're young. The reality is they often need far more support. Other factors then set out beneath, so the seriousness of the offence. Obviously, youth court cases can often include knife-point robbery, sexual assault, things like that. So it's worth bearing that in mind. The number of youth witnesses to give evidence. Obviously, the courts then the more specialised approach and technical approach taken to cross-examining even evidence in chief for young people. And it's worth bearing in mind of that as well. Obviously, any defence witnesses can count within that number. In addition, if there's a multi-handed youth case, then again, that can add to the complexity, and also tying into the point just made before, that there are a number of co-defendants. If you're then cross-examining them, all of that can tie into the complexity and the number of witnesses that you have to deal with. As well, also worth bearing in mind, are there any legal arguments that are likely to be had? So Section 78 applications, any disclosure issues, anything like that, that adds to the complexity of the case. And finally, thinking about your client themselves, Are they particularly vulnerable for any reason? Do they have any mental health problems? Have they had any particular difficulties in their background that would mean they might need additional assistance, short maybe of an intermediary or anything like that, but just that means things will be a bit more difficult for them to understand. And it might even be that just because if they previous good character, and that it can be quite a daunting thing for someone, a youth with no experience in the court system at all, to then come in and go through the criminal trial, that even that in itself can be a ground to help bolster an argument as to why a certificate could be granted. And then finally, looking at sort of the benefits that this offer. Obviously, then you've got two people sort of dedicated to working on the case, so you can fully explore any avenues on the client's behalf. And since then, there's obviously a financial advantage to both parties involved. From the instructed advocate's perspective, then there's obviously a significantly higher rate of pay for that. But then also then from the litigator's perspective, it's far more likely that they will then enter into a situation where they can apply for an uplift for their fees and escape into hourly rate in relation to any billing in relation to the file. So it's certainly a situation where if it's an appropriate case, it can be in the client's advantage to having more people working on it, and also to the advantage of everyone involved in the case in terms of getting proper remuneration for the work and the effort that's being put in on the young person's behalf. So that's then a sort of very brief overview of the certificates for counsel. And that sort of brings us to the end of the three topics that we were going to go through.